Good morning, everyone. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. Now, usually I like to keep things within the past week, but oftentimes, because the Immigration Service has issues that take quite a long time, we go back prior to the week. So I like to dive right on in. And today we've got a few things I want to talk to you about and remind you about and let you know about. The first thing is that biometrics for H4, L2s, and E dependents is still suspended. The temporary suspension was supposed to last only until May 17th of this year, but they've actually gone on and extended that further out until September 30th of this year. So if you are filing to extend or change your status to H4 dependent, L2 dependent, or E dependent, the biometrics will not be needed upfront, which means you do not need to include that biometric fee. However, this is completely discretionary. So if you receive the biometric notice for the H4, L2, or E-dependent application, you want to make sure that you do attend that biometric appointment. The appointment will not be a mistake. You definitely want to make sure that you go. But by and large, they are suspending those biometric appointments. It is yet another way for them to try to manage and work through their current backlog. The next thing I want to talk to y'all about this morning is the USCIS fee increase. While we haven't heard anything about anything further, I should say, about the proposed rule to increase the filing fees on most of the applications that we file with USCIS, that just means that USCIS is still working on this rule. They are still sorting through all the comments. It does not mean that they have decided not to move forward with that fee increase. So don't wait, get those applications filed now. Especially for your family-based applications, those are going up. Some of our employment-based applications are also going up quite significantly. So you want to get those into the Immigration Service before the proposed rule becomes a final rule, and then we get new increased filing fees. So just keep that in mind, that proposed rule is still out there. The agency is still working on it. Next, I want to talk about filing cases with your medical exam reports. If you are filing for a green card in the United States, a medical report is required. You must have it done by a DHS-approved civil surgeon. And that civil surgeon is going to give you a medical report. It's going to be sealed, and then we're going to send that into the Immigration Service with your application on your behalf. It is not required that we send in that medical exam when we file your application. And frankly, there are some times based on strategy that we may not want to file it at the exact same time. The medical exam is only valid for a certain amount of time. For quite some time, many years, the Immigration Service was taking a very long time to process these applications. The medicals would expire, then we'd have to file. We'd have to reach out to our clients. They'd have to get new medicals. So frankly, it was really a mess. So a lot of us had stopped having our clients file the medical at the time that we filed the application. Now that USCIS is actively trying to work through their backlog, they have been encouraging us for quite some time now to file the medical with the initial application. So I pass this on to you. Let's file the medical with the initial application. If that is the only thing holding up the application, we will receive a request for further evidence requesting the medical. Oftentimes we are seeing applications approved right after we send in that medical report from the civil surgeon. So we save ourselves the RFE time, the back and forth with the agency, if we file those medicals upfront with the application. But again, you definitely want to talk to an attorney about that. There may be a strategy reason why you may not want to send that medical in up front. But barring anything, sort of amazing going on in your case, if we think it's a cookie cutter case, if we think we can get, an approval right off the bat, then we're definitely going to send in that medical right when we send in the initial green card application. So just keep that in mind. But the Immigration Service is definitely encouraging us to send the medical exam in from the civil surgeon with with the initial green card filing application. The other thing that we are seeing and have been seeing for quite some time now is on the family-based green card applications. We are seeing those cases be approved without an interview. Normally, family-based green card applications, you're required to go to whatever your local immigration office is. You have an interview with a local immigration officer. So if it's a family-based case, if you are petitioning for your spouse, for your minor child, if you're petitioning for your parents, um, you must go into the local office and have an interview. In the effort to sort through the immigration backlog with all of these cases that have been filed that were sitting during the pandemic, the Immigration Service has now been approving family-based cases without an interview. So that is 100% discretionary. They can always schedule you for an interview, but we are seeing more and more and more cases that are clean cases. The documents that are submitted really show a bona fide relationship. If we're talking a family, a marriage-based case, um, you know, and so the Immigration Service is really making great strides to get those cases approved and essentially dig their way out of the backlog. So make sure that when you're filing your case, we want to make sure that we've got really, really good documents that support your case and show that you meet the criteria. And in some cases, the Immigration Service will, in fact, approve your case without an interview. So it is not a mistake if you receive a green card in the mail instead of an interview notice. But remember, it's completely discretionary whether or not they approve without having an interview. So I always tell my clients we're going to prepare for an interview. And if we don't get one, great, but we're absolutely going to be prepared. We're not going to be sort of, at the last minute scrambling to get you prepared for an interview. I'd rather have you prepared for an interview that doesn't happen than not prepared for an interview that does happen. The next thing I want to talk to you about, and it's really just a reminder, we're still in H-1B cap season. I know y'all are completely tired of hearing me talk about it, but it's not over, so I'm still going to talk about it. If you were selected in the lottery, and if you were selected in the lottery by checking your My USCIS account, if for some reason you haven't checked your My USCIS account, go and do that today. Literally, stop listening right now and go and check your My USCIS account. If you were selected, those H-1B applications need to be filed with the Immigration Service by June 30th of this year. So again, do not wait until the last minute to start preparing your H-1B cap subject application. You want to make sure that you get those in advance of the June 30th deadline. The next thing I want to talk to y'all about are the I-9s. So the I-9 is a form that we fill out for all of our employees that shows who they are. So it gives us their identity, and it also shows us whether or not they are eligible to work in the United States. That form is filled out by employers across the country. During COVID, Immigration and Customs Enforcement, the agency that really oversees the I-9s and is responsible for I-9 audits at work sites, understood that it was very difficult, that people were, all of a sudden thrust into working remotely. And ICE said, okay, we totally get that. We are going to suspend the requirement that documents supporting the I-9 requirement be seen in person. We have been in that scenario for quite some time now, since 2020. But we always knew that that would be temporary. We always knew that at some point ICE was going to come back and say, okay, this is over. Reviewing documents remotely is over. We now need you to go back to business, back to normal, and review those I-9 supporting documents in person. So that day has come. Those flexibilities, that suspension of in-person document review formally expires July 31st of this year. ICE has announced that they will give 30 days past that requirement, past that end date, to have all of your ducks in a row. So you'll have until August 30th of this year. However, we knew this was coming. So I would highly recommend that if you have not started to go back and look at all of your employees where their I-9 documents were reviewed virtually, that you start that today. That you come up with a system that works inside your organization, no matter how large, how small, that those I-9 documents are now being reviewed in person. I suspect, I do not know, I do not have top secret information, but I suspect and predict that we will see more I-9 audits to make sure, and for the agency to do spot checks to make sure that employers have indeed gone back and looked at these documents in person. And I do expect to see more I-9 audits coming our way. So if you need help with any of your immigration issues, your I-9 audits, filing for your spouse, filing for an employee, feel free to reach out to the office at 954-903-1337. We are more than happy to help. And the last thing I'm going to do is another national interest waiver tip. I've been doing these for a few weeks now and gotten some really good comments, some really good messages offline. So I wanted to keep doing that because you all seem to find these helpful, which makes me happy. The tip this week for the national interest waiver is that premium processing is indeed available for the I-140 national interest waiver application. So the national interest waiver, it's a green card category. You must show that the proposed endeavor, your proposed job, in your proposed industry has both substantial merit and national importance. You must show that you as an individual are well positioned to advance you in your particular niche within your industry. You can do that either by being employed by someone else, or, and this is what a lot of people like about the national interest waiver, you can self-sponsor. So you don't actually need an employer. You can show the Immigration Service, hey, I'm really great at my thing, at my little piece of this puzzle, and I can advance it on my own without an employer. And so the third prong is that on balance, we need to show that not only what you're going to be doing is going to be beneficial to the United States, but it's beneficial enough that the Immigration Service determines that we bypass the regular green card process, which includes 1, a job offer, and 2, advertising for qualified U.S. citizens and current green card holders to perform this particular job. So if we think we have met all those qualifications, we do have the option of filing this application using premium processing. The current premium processing fee for national interest waiver applications, and this is the government filing fee, the current government filing fee for premium processing is $2,500. And with that extra fee, the government will process just the I-140 piece of your application within 45 calendar days. So that cuts out and streamlines and expedites your green card application quite significantly if you qualify for a national interest waiver application. So that is my national interest waiver tip this Monday morning, which is you can indeed premium process that application. And currently the Immigration Service has said, if you premium process, they will give us something in 45 calendar days. So that is all I have for you this Monday morning on Beyond the Soundbite. Have a wonderful rest of your Monday and a great rest of your week. And if you need any help with your immigration needs, feel free to reach out to the office at 954-903-1337.